Alberta's labor market is slowing, with employment falling 0.6% in August, marking the second consecutive monthly decline and pushing the unemployment rate to 8.4%. In this environment, understanding rights and obligations around layoffs and terminations is more important than ever for both employers and employees. With more on this topic, I'm joined now by Joseph Oppenheim and Lauren Bartaluk. They are both partners at Carbert Waite's Employment and Labor Law Group. Good morning. Great to have you both in studio.
Good morning.
Good morning.
Lauren, we'll start with you. Maybe just tell us a little bit more about Carbert Waite's employment group.
Sure. So Carbert Waite is a litigation-based law firm in Calgary, and we have a very large employment and labor practice area where we represent both employees and employers.
Excellent. And let's dive into this a bit more, Joseph, with just those common challenges you see both employers and employees run into.
Well, from the employee side right now, with the economy the way it is, we're seeing a lot of terminations of employment, unfortunately, as businesses contract. And so I'd say that's the most common issue we're seeing now.
Yeah, it's an unfortunate situation for sure, but a good topic, because if this happens to someone, what rights do employees have when they might be dismissed from their employment without cause?
So fundamentally, all employees in a non-unionized environment are guaranteed certain rights under the Employment Standards Code. When it comes to termination, they're guaranteed a certain amount of notice or termination pay. It caps out at 8 weeks notice, depending on how long an employee has been with an organization. And then above that, we look to the contract, the employment contract, which can be drafted such that an employee's rights are more generous than what the code guarantees, or sometimes limited to only that which the code guarantees. And if the contract is silent on severance, then we're into a gray area called common law notice or reasonable notice. And the courts look at the particular circumstances of the employee and make a decision based on weighing a number of factors, such as age of the employee, seniority of position, and so on. And that can cap out at around 2 years.
Well, let's talk about the employer, Lauren. Basically, what issues should they consider regarding the unfortunate event of having to terminate an employee?
Well, first and foremost, we strongly recommend that all employers have in place employment contracts for essentially all of their employees. So the contract will set out all the rights and obligations and terms of the employment, but perhaps most importantly, the employment contract can also set out what will happen if the employment relationship is terminated or if it ends. So in other words, at the time of hiring, an employer is able to decide how much notice or payment instead of notice that they're going to provide to one of their employees when they terminate their employee years down the road. So hypothetically, for example, you could have a situation where if an employer does not have an employment contract in place, that employer might owe their employee up to perhaps 2 years worth of that employee's compensation package upon the termination of their employment in accordance with the common law. Whereas if the employer had a well-drafted termination clause in their contract, they can limit that amount owing to only the amount set out in the code, which are up to a maximum of 8 weeks of the employee's wages.
It sounds like a wealth of knowledge with you two about this situation. Thank you so much, both of you, for coming in today and telling us a bit more about it.
Thank you very much.
Thank you.
Again, Joseph and Lauren are with Carbert Waite. If you'd like more information, just head on over to the website on your screen.